Landmark judgment, the BALCO case and its impact on Indian arbitration law. Parties involved: Bharat Aluminium Co, BALCO, an Indian company, and Kaiser Aluminium Technical Service Incorporated, Kaiser, a foreign entity. Agreement: the two parties entered into an agreement that included an arbitration clause. The clause stipulated that arbitration would be conducted outside India, in London, and the governing law would be English law. Dispute: a dispute arose under the agreement, and arbitration proceedings were initiated in London. The case reached Indian courts to determine whether Indian courts had jurisdiction to intervene in the arbitration process despite the arbitration seat being outside India. Can Indian courts intervene in arbitration proceedings if the seat of arbitration is outside India? Does Part I of the Indian Arbitration and Conciliation Act, 1996, apply to arbitrations with a foreign seat? The Supreme Court delivered a comprehensive ruling in September 2012, making the following important observations. The court held that Part I of the Arbitration and Conciliation Act, 1996 does not apply to arbitrations seated outside India. This means that Indian courts cannot intervene in foreign-seated arbitrations under Part I of the Act. The court clarified that the seat of arbitration is of paramount importance in determining the procedural law governing the arbitration. The choice of seat determines the exclusive jurisdiction of courts in that location. The court overruled the earlier judgment in Bhatia International vs. Bulk Trading SA, 2002, which had allowed Indian courts to intervene in foreign-seated arbitrations under certain conditions. The BALCO ruling effectively eliminated this possibility. The BALCO judgment was made applicable prospectively. It only applied to arbitration agreements executed after 6 September 2012, the date of the judgment. Agreements entered into before this date continued to be governed by the principles laid down in Bhatia International. The judgment brought clarity to the interpretation of the Arbitration and Conciliation Act, particularly regarding the distinction between domestic and international arbitration. It significantly reduced the scope of judicial intervention in foreign-seated arbitrations, aligning Indian arbitration law with international practices. The judgment reassured foreign investors and parties about India's commitment to honoring the principle of party autonomy and maintaining the sanctity of arbitration agreements. The ruling influenced subsequent legislative reforms, including the amendments to the Arbitration and Conciliation Act in 2015 and 2019, which aimed to streamline and modernize arbitration laws in India. The BALCO case represents a pivotal moment in Indian arbitration jurisprudence. It marked India's shift toward a more arbitration-friendly regime, promoting consistency with global arbitration norms and reducing judicial overreach in international arbitration.